So Unit 5, 2 legislations are there as we mentioned. Second one that we have is Probation of Offenders Act. Okay, so we will see what this legislation is all about. So section 3 that we have under this legislation talks about power of court to release certain offenders after admonition. When a person commits a crime, okay, so there are certain crimes where it is possible that what you do is you give a kind of warning to the person. You warn the person that what you have done is very wrong, it is a crime, and this could have been the punishment. But because of some prevailing situations and everything, you are being released. You are not sent to the prison, right? So person is given a warning that what you have done is otherwise very bad. Otherwise, it is a crime. You could have faced this much of punishment, but only because of some prevailing situations, you escape the punishment. Okay, so you should rather be very careful next time. That is what this provision is all about. But now in which all cases or situations can we actually say that this, like a person may be released by simply giving a warning? That is mentioned under section 3 of the legislation. Okay, so it mentions that when any person is found guilty, having committed an offense.
In legal,
sorry?
Madam, in legal terms, such a warning is termed as admonition.
Yes.
Okay.
Yes, admonition or warning can be given by the court and person may be released. That because of some prevailing situation, because you have committed the crime for the first time, or might be it is something where it can be granted, we are releasing you, but otherwise you should be careful, like that warning may be given. So this is applicable in some offenses, not like in every case it can be done. Where can it be done? There are some offenses which are not considered as like very serious or something. Okay, so that's for that provisions are being mentioned. So there are certain offenses wherein sections are being mentioned. Like take for example 379 of IPC, which relates to theft. Maximum punishment is some 3 years. We have section 380, section 381, theft by clerk, theft in dwelling house. Section 404, dishonest misappropriation of property. Section 420, cheating and dishonestly inducing delivery of property. Even though punishment might be different, like in this one 420, it's maximum of 7 years, but even then court considers, or court may consider, depending on other situations prevailing, that this is something where probation can be granted. Okay, it just happened by the person, maybe he is not a habitual offender, or he's not having a criminal record, or otherwise he is not bad, because of some prevailing situations he ended up committing the crime. So all these sections, if a crime is committed under these sections of IPC, or any offense punishable with imprisonment not more than 2 years, or with fine, or with both. If punishment is not more than 2 years of imprisonment, right, even if it is with fine, lesser than 2 years punishment, or with both, whatever, in such cases, okay, even though it is under IPC or some other legislation, and there is no previous conviction, the person is not being convicted previously, has not committed any kind of crime, it is proved against him, the court by which the person is found guilty, if the case was filed in magistrate court, then magistrate court would take the decision that okay, fine, we have found him guilty, but having regard to the circumstances of the case, considering the other situations, other circumstances of the case, plus nature of the offense, plus character of the offender, everything, considering every single thing, what we have found is that it would be better. Okay, it would be better that instead of sentencing him to imprisonment or releasing him on probation, good conduct under section 4, releasing him after due, we do not even want to sign a bond that you need to maintain good behavior or something, but we can straight away release the person, giving a warning. Okay, it might happen mostly in case of theft and all. Okay, like a person has committed theft in dwelling house, case was filed, and he might say that, okay, because of COVID, I was not having anything to eat, so I ended up committing this crime. And I do not have any kind of criminal record or anything. Their court might say that, okay, fine, because of the situation and everything taken into consideration, we are giving you a warning that whatever might be the situation, that do not give you a liberty to commit an offense. So they might consider that it is better that we release the person, taking into consideration the situation under which the person committed the crime. Okay, so in section 3, it applies in case of these offenses where sections are mentioned, or anything where punishment is lesser than 2 years, or with fine, or with both. Court may release the person after giving warning, considering the situation, nature of the offender, etc. Okay, is it clear?
Clear, madam.
So this is about section 3. Simply person will be released based on the warning which should be given.